If you've got a home that you want to pass along to the kids at some point, you're going to want to listen to this episode of Wealth Protector TV. Our founder at Barth Calderon Law Firm, Harry Barth, is going to break down a certain type of trust that allows you to avoid estate taxes on your personal residence that you're giving to the kids. So let's go jump in.
Well, good morning, everybody. It's Harry and Paul, and here we are again on next edition of Barth Calderon University.
Yeah, and Wealth Protector TV. Thanks everybody for joining. Harry, I know you're going to jump into qualified personal residence trust. What's going on there?
Yeah, so I want to talk a little bit about this estate planning technique and tool. I think it's a really important tool, and I'd like to share some of the details with everybody so you can all have a working knowledge. So, and I want everyone to understand that this is an express part of the Internal Revenue Code. This is not, not on the fringe. This is right in the code. And it's basically designed as a tool to help us pass our primary and or one other secondary residence, vacation home, second residence, to the next generation without the inclusion of the house or the second residence in our estate for federal estate tax purposes. Now, that could be a lot, especially in California and other states. You have a $4 or $5 million home. The price to pass that home to the children could be $2 million of transfer taxes alone,
right,
just on that property. So this tool and technique was designed to help make that transition a little easier.
And not for commercial property or rental property, none of that stuff.
Only for a primary residence and one secondary residence. So you could have one residence in one personal residence trust, another residence in a second personal residence trust, no more than two residence trusts. And that's it. That must be a primary residence. Should it cease to be a primary residence, then the qualified personal residence trust is over. So here's how it works. So basically, I'll describe it in terms and related to my family so everyone can understand it. So Harry and my wife, Tess, we create this personal residence trust. Harry and Tess can be the trustees of this trust. And we make a gift of our home to this trust and reserve a period of time that we will live in this house rent-free. Could be my choice, 10 years, 12 years, 15 years, 20 years, 25 years. And at the end of that time that we have selected, assuming that we are alive, we have to outlive the term that we've selected. The house that I put into this trust will then pass to my children, or a trust for my children, completely income tax and estate tax free.
Can you change the time period, or is it set once you put it in there?
Once you put it in, it's set.
Okay.
So, but we choose the time period up front. And so and understand that it's interesting because when we make a gift of our home to this trust, we have to have our home valued. So we have a present value of the home. If there's no mortgage, it's the full fair market value. If there's a mortgage, it's the net equity in the home. And we have to have an independent evaluation, so we get it done. And then we make this gift. Now, the longer in distance it is until it transitions to my children, the less of my current federal gift tax exemption I will use up, because a gift to my kids 25 years from now is worth less than a gift to my kids in 3 or 4 years from now.
Right.
So that's kind of baked in and calculated into the way in which it is constructed. So very important. So let's say, for example, you have someone age 70 years old, and we set up a 15-year qualified personal residence trust, house worth $1 million. We make a gift in, probably the amount of the gift is more like $800,000, because the gift won't happen until for example, the 15th year from now. And all of the appreciation on my home, and homes are pretty good appreciating assets,
Right.
does not count and will completely escape estate taxation. So I may use up $850,000 of my gift tax exemption today, and I may be able to get, if my house appreciates, a $2.5 or a $3 million asset to my children without any tax, and that's worth about $1,200,000. And we have to understand that today, that we have a confluence of two different things. We have a appreciating asset, hopefully our homes, all right? And then if we have liability or mortgages against them, we have amortization of the mortgage debt, so the amount of equity is growing. And a very distinct possibility in a couple of years of the federal estate tax exemption being cut in half and reduced significantly. So while today we might have the room for the growth of our house not being included in our estate, that might not necessarily be true after December 31st, 2025.
What if you die before the period, Harry?
I'm going to get to all of that, promise. So what happens here is, let's first understand during the Cupra period, or the 15 years or the 20 years, the 25 years that we reserve, we live in the property and we don't have to pay any rent to anybody. This is it's called a grantor trust. So we still get whatever property tax deductions, whatever interest deductions that we're entitled to under federal and state law still accrue to us along the way. So we don't necessarily feel very much different. If we successfully outlive the term of the trust, so if we live past the 15th year, then that property at its full value, whatever it is at that point, I said will transition to my children, income tax is estate tax free. Of course, we're always worried at that point, what about the kids, all right? What about the kids' spouses, the kids' liabilities, the kids' bad businesses? So when it transitions to the children, we usually transition it into a trust for the children. Now owns the home. So that home becomes an asset protected asset for our children. And so the children's liabilities, children's marital status, and other children type issues, that asset is not available to satisfy those claims because of the way in which we've constructed it. And also, due to a very unique aspect of this law, that my wife and I reserve the right to rent that property from the trust that I've created for my children for as long as we wish, as long as we live. So
you're not kicked out. The kids
No,
are not kicked out.
they're unable legally to kick us out. And, it may sound counterintuitive, but the ability to pay that rent allows us to, once again, lower our estate and transfer more money to our children, estate tax free, and getting it done. So that's it. Good. And then I want to revert back to your question, and your question is what happens if we die before the completion of the Cupra term? Well, in most cases, almost 98% of cases, we have what is known as a reversion. So in a reversion, the house will then revert back into my estate as if I never had the Cupra at all. So basically, the house is now that $3 million house, $2.5 million house is now back in my estate, and I will pay estate taxes on it. I didn't make it. We never got it to the point where it was able to transition to the children. But no harm, no foul.
Right.
If we used up $850,000 of my exemption to get it in, and we passed before effectively making the transition to my children, we'll get the $850,000 back. So it's the same as if it's in other words, it's you no matter what you do, you win, because there is no downside in creating a qualified personal residence trust. So there are a couple of issues that we need to talk about. So that's what happens if somebody dies along the way. Another question that we get is what happens if we want to sell a property? No problem. The qualified personal residence trust would sell the property, would be the seller, and we would then receive the proceeds of the sale. And then we have 2 years from the time that, nothing to do with the income tax that may be due on the sale, but we have 2 years from the time that we make the sale to make an acquisition of another residence within the Cupra. So if I have a 15-year Cupra, And at the end of the 5th year, my wife and I sell the property and buy another property. So basically, the Cupra sold the property and the Cupra bought the new property, and it just continues on into until the 15th year. If there's excess cash, that cash must be returned to me. I can't keep excess cash in the Cupra. I keep 6 months expenses in the Cupra, and that's it. So
excess cash above the value of the home you're talking about? Or?
yeah, so if my house is $2.5 million, I sell the Cupra sells it for $2.5 million and buys a new residence for $2 million. I have $500,000 of extra cash.
Right, okay.
That $500,000 of extra cash needs to be returned to me. If I don't buy a replacement residence, the full $2.5 million is returned to me.
Outside of the Cupra, no longer.
Cupra no longer exists because there's no longer a qualified personal residence inside the Cupra.
Mhm.
There has to be a qualified personal residence, but we do have the means. People are not locked into any particular location whatsoever. Very, very nice trust. And I think when structured properly, it becomes a very good tool for asset protection of our home, because what we own at this point is no longer the home. We own the right to live there rent-free for the Cupra term for the 15 years to 20 years, but we don't own the home anymore. The home has been transferred to trust. So it provides, I think, a modicum of asset protection. If God forbid, I have an automobile accident or professional liability, my home is owned by the trust and not owned by me. And upon its transition, it transitions to the trust for my children.
Harry, what if you get long-term illness and parents need to move out of the house into a assisted living facility? What happens?
Well, it doesn't matter. As long as the home is still a residence, all right, it could remain inside the qualified personal residence trust. Okay. It's if you convert the residence to a rental property, then the qualified personal residence trust ceases. And at that time, we would move the home into an appropriately designed limited liability company for commercial type asset protection for the asset.
Got it.
So repeat, it's only for as long as it's a residence. Of course, when it moves to the children at the end of the 15th year, if we're fortunate enough to live that long, then my children would have a trust, and perhaps the trust would form an LLC. Now it's a rental property, but the renters are the parents. And they even have things today where, if the children wanted to, they could gift us back the value of the rental income, so we wouldn't have to necessarily pay the rent. There's also something a little beyond the scope of what we're talking about, a reverse Cupra, where the children gift us back a certain interest in the Cupra during the period of time that we live there. So there are a lot of options as we get to the end of the Cupra that we should take into consideration.
Yeah, it sounds like you can really tailor the solution.
Yeah, it's very, very, very good. Now, there are a couple of downsides, if you want to consider them downsides, but what you would say cons when we talk about this is that when the children receive the asset, receive the homes as a result of the termination of the Cupra because we outlived it and went into trust for them, the children will not get a step up in basis on our death. The children will take our carryover basis in the property, which is usually works out fine. It's a lot less than the estate tax. And a concern that we have today, which we didn't have a couple years ago, is that when the home transitioned from myself and my wife to my children in California, but this doesn't apply in every other state that we work in, but in California, the new Proposition 19 kicks in. And even though we are renting the property from our children's trust, it's considered a change of ownership. And 15, 20 years later, the property will be reassessed with higher property taxes as a change of ownership. Up until the time of last November, under Proposition 13, the transition of a primary residence anyway to children was, no matter what the value was not a reassessable event. And right now there is legislation potential to go on the ballot for November of 2022 to perhaps repeal Proposition 19 and reinstate the parent-child exclusions, which would be very, very beneficial for Cupra. So Cupra is, I think, a very, very good tool for people to consider in the right set of circumstances. If we have a large home and we have a fairly good sized estate, given the fact that the estate tax exemptions most likely will be reduced, the consideration for analyzing a Cupra qualified personal residence trust and how it fits in someone's estate portfolio, I think is very, very important. I think this should give everybody a really good smattering of the benefits of a qualified personal residence trust. And we look forward to talking to everybody and anybody who would like to inquire further about this particular tool. And I look forward to our next session, where we will continue on Wealth Protector TV with concepts and ideas that will be useful for everybody in language that we hope that everybody can understand.
Harry, as usual, great information. Thanks everybody for listening. And Harry, I know we're going to see you again soon here.
All right, Paul, thank you so much. Have a great day.
All right.
Bye.